head of the U.S. Impact. Oh, there you go. Head of the U.S. Impact Investing Alliance, which is sponsoring this call and also sponsors our Policy corner of ImpactAlpha, where and has been super helpful over time, Fran, for keeping us up on all the policy developments. So, hi, Fran.
Hello, David. Great to be with you today.
And then also, just to help kick us off, Jorge Fontanez from B Lab, and I know you all are partnered up in. Do I have it right? The Coalition for an Inclusive
Economic Growth.
Economic Growth. Got it.
Yes. Yes. Hi, David. Good to be here.
Welcome, Jorge. So, Fran, just give us a little scene setting here of why we decided to pull this together. It's a little like, I think of it as counter programming. Everybody's very keen on the presidential election and the election in general. These court cases and the sort of new legal landscape will prevail regardless, frankly, of the election. So thank you for keeping us tuned in on that. So what are we up to here?
Yeah, well, first, David, thank you to you and the ImpactAlpha team for hosting this discussion today. I have an aspiration that the policy corner becomes like the policy living room, and maybe this is the closest we get to the policy living room is, a conversation with these great speakers. So just as you said, the elections, we have the beyond the undertow, we are in the full thrust of the elections. We are all scenario planning and thinking about what these results might mean for the future of our work. But as you said, regardless of election results, there's been this major shift in the way Washington operates, and it has massive implications for a range of constituencies, and including our sector. So recent Supreme Court rulings will significantly reduce the authorities of federal regulators and could even undermine, in our view, our democratic institutions. So today, we'll be exploring that legal landscape with a specific focus on 3 cases. The first is Loper Bright versus Raimondo.
All right, let's hold the specifics and get into that
Okay.
with right, because I think we're going to dive deep into the particulars. Sure. But let's just set a little bit of a context here, which with Jorge also, which is what we're looking at is what can investors in particular, but stakeholders in general, do moving forward. So there's a legal analysis, obviously, which we'll get into, but there's a sort of strategy and tactics discussion, which I think will push us forward. And maybe and sorry to cut you off, Fran, but I want to bring Jorge in, and then I want to introduce the speakers, and then we'll get to the specifics of the cases, if that's okay.
Happy to
Jorge,
build on. Go ahead.
Yeah, maybe you can build on that and also tell us a little bit about the coalition.
Sure. I mean, just building first on Fran's comments. I've been saying how it feels like the alphabet is under attack, whether we're talking about ESG, DEI, or LGBTQ issues. And the recent Supreme Court developments around the Chevron doctrine really is another consequence of anti-ESG rhetoric, right? And it creates some real constraints to advance environmental, social, and governance goals with respect to federal policy. So I know one of the things that we're going to be looking to talk about today is like, how do we respond to this shift? When we think about the consequences, we think a lot about how this continues to potentially erode public trust in government. It's sector agnostic. And this is an opportunity for investors and business groups and businesses such as B Corps, who are good examples of how profit and purpose can coexist, to fill the gap in leadership, to demonstrate what's possible. And that's partly what we're doing in partnership with the U.S. Impact Investing Alliance, the Coalition on Inclusive Economic Growth, does just that. It's a forum for us to connect and convene, share best practices, but more importantly, begin to scenario plan about how we mobilize together in a moment where policy and regulatory issues are at risk.
Great. And now let's just introduce and bring in the other speakers. And then I promise we'll get to all the cases, Fran. So Dennis Kelleher, welcome from Better Markets.
Hi.
I think a lot of folks know you, Dennis, from many appearances and a long history. But I know you've been were a lawyer for many years, a Senate staffer, and now the head of Better Markets. Rachel Robasciotti from Adasina, another old friend of ImpactAlpha. Welcome, Rachel.
Thank you. And it's Rachel Robasciotti. I'm the founder and CEO of Adasina Social Capital, also the co-founder of the Freedom Economy Business Association. So I'll be talking a bit more about that later.
Good. I wanted to get into, I knew I was going to get that wrong, Rachel. I was going to call you Rachel R, but thank you for that.
No one knows it unless I pronounce it for them. So I figured I'd help out.
And Rick Alexander from the Shareholder Commons, and I think earlier B-Lab, if I'm not mistaken.
Yep, David, great to be here. And yes, I had a nice run at B-Lab, especially focusing on legal form and how legal form could contribute to a more responsible for-profit economy.
Okay, so let's jump in and Fran, I did cut you off, so I know you had some thoughts, and maybe you can help just introduce and bring Dennis in as well. So set a little context.
Terrific. Thank you, David. Yes, so we will be speaking today specifically about the implications for 3 Supreme Court rulings. The first is Loper-Bright versus Raimondo, which overturns a 40-year-old doctrine known as Chevron deference, as Jorge mentioned, which will hamstring federal agencies moving ahead. And again, Dennis will talk about each of these in a moment in greater depth. The second is Corner Post versus Federal Reserve, which opens the statute of limitations for when plaintiffs can challenge regulations. And finally, the SEC versus Jerkesi, a decision that weakens regulatory enforcement by limiting the use of administrative courts. And I just want to say at the top before handing it over to Dennis that this may seem a bit wonky and unapproachable. I think it's tempting to focus just on the election and the drama around it. But these items, the implications of these rulings is essential for impact investors and impact businesses to pay attention to. We need to have a clear-eyed view of what these rulings mean for our public policy priorities and indeed the future of our democracy. So I'll leave it at that. I have some more to say, but I'd love to hand it over to Dennis to talk a bit more about these rulings and the implications of them.
Yeah, Dennis, what's at stake and what's the context for all this?
Sure. Well, look, let's start with the bottom line. The bottom line is that the legal, regulatory, and political arenas are going to be much more challenging because of these recent cases, which they really need to be viewed in combination with a series of other related cases. And together, as I like to say, they form a mosaic of Supreme Court decisions that will synergistically interact, and they're going to result in a reordering of the relationship among the executive, legislative, and judicial branches of government, and frankly, as well as the relationship between the government and the American people. Now, as I mentioned to David yesterday, because of the limited time, I'm only going to be able to touch on a few of the highlights, but I did write up a more detailed analysis that we've posted on our website this morning at www.bettermarkets.org, where we really go into some detail both as to the macro picture and implications, as well as the cases themselves in a lot more detail. As Fran said, it can get a little wonky, so I'm going to stay away from the wonky parts, I hope. But the details are important, and they're in the memo on the website.
And
So
I think some of your Better Markets colleagues are on the line, and maybe there it is. Somebody just posted it. Great.
Okay.
So there's the link.
Okay, great. So, but
this,
as Fran mentioned, we've got, really 3 big cases from the end of this term. Loper-Bright, which is getting all the attention because it ended Chevron deference, which required agency or courts to defer to agency expertise, purportedly when it was only an ambiguous statute, but the courts were not limiting themselves to that, particularly the frankly, biased, outcome-oriented courts we're dealing with nowadays. Jorge, as she mentioned, it actually held that there's a constitutional right to a trial by jury for fraud cases or cases that so-called sound in common law. And that was a particular an SEC case. But what it means is the SEC is going to have to bring a lot more cases in federal court. But the implications are going to be for other agencies. And there's already been lawsuits filed just since that case trying to throw out administrative proceedings in other arenas, like FINRA, for example, which is supposed to be a self-regulatory organization protecting investors. And finally, Corner Post eliminated the general 6-year statute of limitations under the Administrative Procedures Act, which just has everybody shaking their heads because it's going to open up a Pandora's box where even decades-old rules are going to be able to be challenged. And we can't forget that they're also from 2022 was West Virginia v. EPA, which relates to what's called the major questions doctrine. And that decision by the Supreme Court held that rules that courts determine to be of, quote, vast economic and political significance, close quote, require very explicit congressional authorization. So you've got to look, there's not only those cases, we talk about some other cases in our memo too, but those are the core of the recent cases. And those cases mark a dramatic and historic power grab by the Supreme Court, decidedly at the expense of the executive branch, but also in many ways at the expense of the legislative branch as well, although it kind of cuts both ways depending upon the case in terms of the power of the legislative branch. Now, the details of each of these cases are obviously important, as they always are. And as I say, we discussed them in the memo, but it's equally important to understand that the conservative majority on the Supreme Court is sending a very clear message to all of you with these cases and everybody else in America. And that is that they are very serious about dismantling the administrative state, or what they call the administrative state. And those are all the agencies that everybody's familiar with that focus on protecting the health, safety, well-being, financial security of the American people. The administrative state is not some crazy thing out there that's a building somewhere. It's actually people who work at agencies to clean air, clean water, shareholder rights, our equity markets, et cetera. They're also sending a clear message that they and they alone are going to decide what a statute means and what Congress can and cannot do, applying aggressively the so-called separation of powers doctrine. So David wanted me to quickly talk about what to do given this new macro legal landscape, leaving the details aside. And so for pending cases, in our view, there's two things. First, you need to pay much more attention to the text of the statutes and the legislative history, obviously. But you need to do, and I mean, it's obvious to everybody, it always has been, but we need to do it and spell it out in a way that's simply not been necessary before. And this is true both for matters currently pending at regulatory agencies and for those now being litigated. We're filing an amicus brief tomorrow in the big SEC climate case, where most of the brief is all about the core SEC authority to require disclosures. The second thing people really have to do is be much more creative and thoughtful. People really need to think differently when thinking about these cases and what they want courts to do, particularly those that are likely to be biased against you. And frankly, those courts are growing by the day. There's a very good recent example that I'll use in a CFPB case. The CFPB, the Consumer Financial Protection Bureau, for those of you who may not know it, determined that discrimination is an unfair act or practice prohibited by the Dodd-Frank Act. Now, you won't find that necessarily stated explicitly in the Dodd-Frank Act. It delegates to the CFPB to police unfair acts and practices. So predictably, the Chamber of Commerce and the Bank Trade Group sued as soon as they announced it. And no surprise, the district court in the Eastern District of Texas ruled against the CFPB, finding that it exceeded its authority as the industry claimed. It's currently on appeal to the Fifth Circuit, where the CFPB, interestingly and creatively, in my view, argued that the rule that discrimination is an unfair act of practice isn't just about Black or brown people. It's also about debanking conservatives and religious groups. So Republicans have repeatedly raised this concern that those groups are improperly discriminated against. And the CFPB argued, and I believe correctly, that under the district court ruling, it would not even be able to investigate a claim of intentional religious discrimination to even determine if it was unfair. And in my view, that's kind of thinking about discrimination as an unfair act of practice in a broader way, in a way that isn't usually thought about, very targeted and tailored to the court that they're in, which is an incredibly hostile court. So those are two things to do with pending matters. One quick thing to do for future matters. You have to be in or get in the legislative game. If you're only in the regulatory game, you start in the 5th inning and you're down by 5 runs. Better Markets, or at Better Markets, we've viewed the entire policy process as an ongoing, frankly, never-ending interactive continuum. We've strategically tailored our advocacy to ensure that we're optimally positioned for success at each point along the continuum, while being prepared for the inevitable disruption due to actions by other actors along the continuum. That, frankly, is only going to get a lot more challenging now. So thanks for listening. And as I say, there's more information at our website, bettermarkets.org.
Dennis, thank you. Just to sort of pull it together, I mean, think what you're saying is that, and we've seen that, and you mentioned the SEC climate disclosure rule, is that essentially any, and certainly any controversial or path-breaking regulation is now sort of just routinely challenged in court, and so that there's not, it's going to be like, I think we had a call, Fran, we talked about the climate rule several years ago. We were waiting. It finally came out and then stopped again yet by litigation. And so now, and it sounds like litigation that can now reach back for regulations even that were well settled many years ago. So for investors, they don't really know what the landscape of regulation and rules are likely to be. What does that mean for just the investment, the investment environment?
Well, I think that it means a lot of different things. First of all, you're right. Virtually every rule is going to get sued on that the industry doesn't like. And in fact, the Supreme Court has created an incentive structure that they'd be fools not to sue under almost every rule, because the odds of the rule being at least cut back, if not thrown out, have increased materially. Which is why people have to strategically engage with both the regulatory process, the legislative process, and the judicial process in a much more sophisticated way now. The impact community is the bullseye of the target, right? Let's face it. And the right wing, the Federalist Society, the Chamber of Commerce, the Wall Street banks, the Republican attorney generals have all been very clear. This is not a secret strategy, right? This is a strategy they put in place over the last decades. These 6 conservative justices, frankly, are the fruition of that long-term strategy. And they want to essentially erase the letters, as Jorge mentioned earlier, I think. They want to erase the letters ESG from the alphabet. Or actually, even worse, more likely they're going to leave them there, but they're going to be contentless or lacking in content or any bite. And so I think to the extent people care about these issues, they've got to engage with the process in a more nuanced way that's reflective of the new landscape.
Thank you. That's a good segue to jump to Rachel. And Rachel, we republished a piece that you had written with your colleagues at Adasina, and you brought in that there's even more cases than these that the Supreme Court and more implications for investors, including with a sort of a attack on civic engagement, broadly speaking. So tell us, give us your broad landscape here.
Sure. So in addition to Looper, Bright, Corner Post, and Jorge, we also highlighted Grants Pass versus Johnson, Alexander versus the South Carolina NAACP, and the Dobbs decision, of course. And those, just in summary, criminalized homelessness, upholded racial gerrymandering in the voting map. And we all know that Dobbs undid Roe versus Wade and allowed for criminalization of abortion in many states. So what we're looking at, if I'm to kind of bring all of the heady legal decisions down to an everyday place, is this is really a power grab. Those who were interested in having a fully inclusive society have built over time systems that support inclusivity, which include our regulatory bodies, right? And certain court decisions that ensured that diversity, equity, inclusion for the populations that were not particularly socially dominant and might face some sort of discrimination or harm, that those communities were taken care of. So what it essentially means is that for those who would not see progress in those areas continue, they've really done a power grab, both in the courts and then also through litigation that continues to come forward. Historically, we've really won in the courts of public opinion on making this case that when like our communities that have been less socially dominant are cared for, that we are all better off, both people and the planet. And those who resist, it's actually a small faction, since the vast majority of us time and time again show in poll after poll that we're kind of on the side of progress. Those who would detract from that, this kind of small majority has sunk an incredible amount of money and energy into these court decisions that ultimately increase hardship for those communities and allow for power consolidation. What's important for investors is that power consolidation equals risk consolidation, whether you're an impact investor or a traditional investor. The more power is consolidated, the less guardrails that you have on corporate greed and all of the other many externalities that corporations can weigh on society. And that's not something that investors are being allowed to correct for, or they're attempting to have us less able to correct for that. So it's more important than ever that investors come together publicly, as we always have, to make demands of those in power and change the laws. That's the kind of like the net piece here. And what does it take to do that? Well, we have to have significant assets. So keep doing your impact investing and double down, triple down on it. Now isn't the time to back down. It's the time to double down. But also, I want you to understand that the attacks on the other side are coming directly at our ability to push forward vast social change. Remember, I said we come together publicly to make demands of those in power. The litigation I mentioned outside of these Supreme Court decisions, the litigation that I've talked about, is that when we come together, there have been recent allegations of antitrust, right, activity that are completely without merit. Most recently, the House Judiciary Committee sent out letters demanding information about woke ESG cartels. They're really trying to scare us from coming together. And they're also trying to stop us from being public about the demands we make. When we publicly do work that supports racial justice, we are now being accused of racial discrimination in court. Look at the Fearless Fund, look at Hello Alice, look at these other decisions. What has happened both for Adasina Social Capital as an asset manager, but also for the entire industry, is that this becomes a distraction unless we have a set of legal resources that takes care of that nuisance. Because let's just be honest, these court cases have no merit. So what Adasina and other impact asset owners, asset managers, asset allocators, and our service providers, so basically the whole impact investing realm of DEI, ESG, and impact, came together to create the Freedom Economy Business Association. And I'll have one of my colleagues put the link to join in the chat. You're not going to be turned away for lack of funds. It is a membership organization with some significant institutional philanthropic support for our charitable work. So it's most important that you come under the umbrella of an association that is set up as a 501c6. We're not as familiar with those, but those are our trade associations like the Chamber of Commerce. And what I want everyone here to know is that trade associations are presumed to have common business interest and a reason for their members to come together. There's a certain amount of built-in assumption that you are coming together for a collective good that is not necessarily based in antitrust collusion, so to speak, which we never were doing anyway, but there's some further protection if you come under the umbrella of a 501c6. So I really just want to say, in response to these decisions, we have to keep coming together. And if you need to, come under the umbrella of the 501c6 for extra protection. But even if you don't, a lot of those antitrust claims are really going to be baseless unless you're sharing cost information with your competitors, for example, and trying to publicly set prices, or trying to collude and set prices, I should say. But we need to continue coming together and collectively, publicly taking stances so that we continue to have the enormous gains that brought about this legal onslaught of attacks. So come join us at the Freedom Economy so that you can outsource your concern about the legal issues. We have legal resources for investors throughout the industry, and no one's turned away for lack of funds, and it is a membership organization. So well, that's what I think kind of the net is here.
Yeah, thank you, Rachel, and thank you for that last clarification, because as I think somebody said in the comments, this I don't want to use too many military terms, but this battle that's being fought is really on all fronts. And as you say, there's challenges to even the ability to work together to challenge the rest of it. So really, it's great to have you and everybody thinking through how to mount a coordinated, well, I won't even say that. I don't have to watch the language.
You can say coordinated. It is completely fine. I want to dispel the myth that we
can't say coordinated.
Collectively.
Okay.
You can say coordinated, you can say collective. Some of our legal advisors who are interested in ensuring that we shall shelter ourselves even from legal attacks have maybe told us in an abundance of caution to stay away from these terms, but really there is nothing that 99.9% of all of us working together over these decades have done that would amount to collusion or anything that would have any merit in an antitrust claim. It's so sad that those House Judiciary letters went out to over 130 organizations a couple of weeks ago, and that we had to spend a lot of time convincing people that it was okay to come together to talk about how to formulate a shared response, like a more of a collective response. It's really unfortunate because these are the tools of movements that make systemic change for the long term. We have to come together. We have to be public. Just know that there is now a legal wall behind your back. No one can really come and attack you. You're not on your own in that way. So
great.
Yes, stay coordinated, stay collected, keep doing what we've been doing.
Absolutely. I will say that at ImpactAlpha, we're very happy to be a media outlet, you know, with the First Amendment behind us and all the rest, to be able to share information and let people get educated. I saw, Rick, that you put in a note about the antitrust issues, but I also want to just engage you from the shareholder comments point of view on sort of what can be done from a shareholder engagement that's always on the playbook, but how can it become more effective?
Thanks. Such a rich discussion. I think what I want to say is, you know, these recent cases we're talking about are really it's an iceberg, and they are just the tip of a 50-year-old, you know, gigantic iceberg. You can go back to 1971 in the Powell Memorandum, where, you know, business sort of came together. We talked about coordinated actions. They realized that, you know, there was good regulation that was stopping them from profiting from, you know, polluting in ways that allowed rivers to, you know, catch fire and, you know, destroyed, you know, many animal populations. And it was just, you know, there was a time of regulation, and there's been a long response. And this is just, we're sort of seeing the culmination. But I want to key in on a word that Rachel said. She talked about this leading to externalities. And look, this is the thing for investors who want to have an impact. We do live in a capitalist economy. The way we allocate most of our resources is we let you know, people with capital invest in companies, and those companies try to make profits and return those profits to the investors. And the idea is, when you're trying to, you know, make that capital more valuable, you're going to be efficient and innovative. You're going to, you know, do all the good things that business can do to make profits. And that's a great system. But there are market failures. It doesn't work when profits can also come from, as Rachel said, externalizing costs. I mean, Milton Friedman himself said that pollution was an externality that needed to be regulated by government. And so in order to have capitalism do its magic, you have to have regulation. What we now have basically in the US, but lots of the world is following, is capitalism without regulation. And that's, you now have a Hobbesian war of all against all. People are just, really, companies are just sort of grabbing for resources, and they're consuming them and they're not replenishing them, whether it's, the carbon sinks that we need to preserve our climate, whether it's freshwater resources, whether it's the kind of social cohesion that comes from having equality and from addressing human rights violations in your supply chain. All of that is put at risk. And the good news, if there's any good news among all, with all that, is investors are almost unique in having both the power, investors as a class, in having the power and the incentive to address some of those externalities. And what I mean by that is, even if you're invested in an individual company that can increase its enterprise value, the value of its future cash flows by, say, using too much of one of those resources, most investors are, when you get down to the bottom line, the beneficial owners, they're diversified. And modern investment theory requires you to be diversified. So they own lots of, if you're a pension fund, you own thousands of companies. And if you're a sovereign wealth fund, you do too. And for those diversified investors who really dominate the investing community, that's a bad trade, because that depletion of resources by one company to increase its returns threatens all the returns across the board. There's a very recent study that came out of a school in France that showed that if we stay on the current carbon trajectory versus a Paris-aligned trajectory, the equity markets will re-rate by 30 to 40%. Pensions are not going to be able to pay off workers. Sovereign wealth funds are not going to be able to serve their citizens if the equity markets re-rate by 30 to 40%. It's a huge hit. And so the thing that shareholders can do is to make sure that individual companies are not benefiting from exploiting these common resources. And so one message that I have when I speak to the impact investing community is, I think it's important for the direct, while there was good regulation, there was really the ability for impact investing to say, we're gonna maximize returns by finding individual companies that can positively impact the economy and also maximize value. I think some of the direction of travel in this new environment for impact investing is to think about the places where the interests of a company and its diversified shareholders diverge, and to make sure that as a member of the investing community, you are helping in a coordinated effort. Rachel uses a lot of good words, in a coordinated effort to limit the ability of companies to do that. So every investor can be an impact investor by making sure, for example, that the companies in their portfolios are paying a living wage, and that they are hewing to a science-based target that prevents deforestation and excess carbon emissions. So that's...
Well, Rick, thank you. I mean, we've said that just because the SEC's rules on climate risk disclosure have been held up doesn't mean that climate risk has gone away, right? So let's just take a hypothetical where in more and more investors understand the systemic argument you're making, but I think how do they exercise that power? So shareholder resolutions is the obvious thing, but to be honest, many of the resolutions are getting 5, 7, 12%. It's impressive. It's good. It's more than it used to be. It gets you on the ballot next year, but it doesn't change the corporate policy. So what are the actual mechanisms that can be used that might have some effect?
So look, it's a long, complicated, coordinated answer. There's a lot of work to be done, and remember, 3-4 years ago, many climate resolutions were exceeding 50% votes, and even last year there were many resolutions that were successful. Looking at the votes that resolutions get is a gives you the skews in the wrong direction, because lots of resolutions are withdrawn when the company negotiates. But I think the long-term answer, David, is that there's more work to be done than there was in the past by shareholders, and really it's resolutions, it's voting no against directors. There's lots of tools. There's still capital allocation. I mean, that can be tricky, but in the debt markets, especially denying debt to companies that are continuing to refinance crazy carbon emissions. So there's a myriad of ways to get there, but I think it begins with sort of an understanding in the community broadly that the interests of diversified shareholders need to take priority to the interest of the financial interest of the individual companies they hold. One document that we just put out there, and I can drop this into the chat, is people should be asking for recommendation from their proxy advisors that are based on this theory. Right now, all the proxy advice in the market, which is incredibly influential, given by there's two companies that dominate this field, all of it is based on giving advice. So that a proposal comes up on climate change, the recommendation that these entities give to their clients is, we'll vote this way because it will maximize the value of the individual company, even though most of their clients are diversified. And so investors need to be asking for proxy advice that actually reflects their interests. And I'll put a newsletter into the chat that funds that.
Jorge, I want to give you a chance to weigh in, and particularly from B Labs. I always think of B Labs as the company, B Corps as the companies that are trying to maximize positive externalities, not get away with negative externalities. And maybe the performance starts the snowball rolling. I think is both your theory and at some level ImpactAlpha's theory as well. So
that's right.
But tell us about what can be done.
Yeah, well, I mean, I'm sitting listening to my colleagues here, believing that part of our work here is also to ensure that good information is being shared with investors in the business community, right? Just recognizing that, we're all doing the work of trying to get that good information into the right hands, but there's a lot of misinformation and disinformation that we're also trying to counter. We've been talking a lot about the role of investors, and one very specific lever, in addition to shareholder resolutions, is capital flow. How do we ensure that the era of greenwashing is behind us, and that investors are also putting their money, in alignment with their values? But even more than that, I think I'm not the lawyer in this call, but the concepts of fiduciary duty of care are absolutely relevant in this moment. Even freedom of speech, the ability for leaders to be able to say that there is a right that workers have to earn a living wage, and that they should be able to live freely and have access to affordable health care and rights to bodily autonomy. These are civil and human rights that business plays a role in protecting. And so we're playing a role here in educating B Corps who, yes, are demonstrating real impact. And we have more and more case studies where we're demonstrating the benefits, for example, of paying a living wage, or ensuring that your supplier base is more green and has low carbon impact. But I think one of the conversations that we want to open up today is, like, to your point, to your question, David, is like, how do we respond to this moment? And how do we get more proactive? I see this question in the chat as well. And one way that we're getting proactive is through partnership, is through coalitions, and looking at the opportunities at a state level. And I think that's one of the things we wanted to touch on today, which is it looks like, for B Lab, we've been in partnership with Ceres. They have a really powerful campaign around freedom, the freedom to invest. And many of our B Corps have been engaged in supporting legislation in California around the importance of corporate transparency, continuing to support disclosures despite the shift with the SEC on climate. And we're hopeful still about that, as well as human capital management disclosures, and also managing climate risk. We're working with other organizations like the Sunrise Project to make it possible for B Corp leaders, CEOs, to testify in state legislatures. Over the past year, we've seen something close to 150 or so bills introduced in state legislatures. Many of them have died and not passed. But the cost of the bills that have passed in about 22 states have been truly material. And it conflicts again with some of the principles that we in business hold so dear as principles, right? The idea of fiduciary duty that we hold as managers. The borrowing costs due to anti-ESG laws are significant. And so we need to bring more and more of this information forward, and we're educating our B Corps leaders to not only understand and have access to good information, but then to actually build the prowess and the courage to also testify, at least at the state level. And we're seeing more and more examples of that kind of policy advocacy. But it does start with education. I think there's more work that we can do in a coordinated way.
Speaking of, I know you mentioned state level, and state level has cut both ways in recent years, and there's been a lot of state level action against ESG, et cetera. Is there an equivalent coordinated effort to advance the freedom economy at a state level?
Well, what we've been doing is supporting congressional fly-ins for B Corp leaders. We've done so now with over 100 companies participating and meeting with their state representatives. And I want to underscore that it's been with congressional offices on both sides of the aisle, with Democrats and Republicans. And part of how we combat or overcome the misinformation is to also educate policymakers. And we're walking away from those conversations with a very positive understanding of the role of B Corps, but also similar frameworks, right? How, it's been said already today, how frameworks like ours that use environmental social governance criteria not only mitigate risk, but then also create value. And those are the kinds of conversations that we're having with policymakers. I think that well, Fran, you might be able to speak more about how we might be coordinating at this level, at the state level. But those are some of the things that we have done so far. We did get over 100 B Corps also to sign a letter of support in favor of the SEC climate disclosures. And now there's an opportunity to see where are the opportunities in states where we can actually be more coordinated and demonstrate that business, in fact, is a force for good, but also demonstrating the possibilities through the work that they're already doing.
Great.
Before I move to Dennis, I just want to answer Jorge's question, or in the broader question about state level organizing. The freedom economy is very aware that many of the guardrails federally are down, and so much of our legislative and litigation tracking is at the state level. So we're tracking what the legislation is that's coming down that will really be the basis, right, for any of the litigation thereafter. We are also coordinating with a broader and informing a broader legislative strategy that's state by state. And that's something that Freedom Economy members can learn more about.
Great. Dennis, I want to give you a chance, and then I want to also open it up to the audience for questions. But
yeah, just quickly, Jorge talking about B Corps made me think people also need to think harder and longer about building bridges and partnering with business. There are good businesses and bad businesses in every sector. There's big, small, and medium businesses in every sector. We spend at Better Markets most of our time fighting, being on the other side of the table than the biggest banks on Wall Street and the biggest financial firms throughout the regulatory process. But the financial industry is very heterogeneous. And there's various interests across it. And there are sometimes when we are on the same side, and sometimes we're on the other side of various levels in the industry. And I think that's true everywhere. And I think people, particularly in the courts, and frankly in the legislature, and whether you're trying to build bipartisan coalitions or not, having a business partner or a group of partners in the business community who are trying to do the right thing, who don't want to engage in a race to the bottom by externalities, who aren't interested in maximizing profits through predatory or illegal behavior, they're getting hurt competitively in the marketplace by the bad actors. And so I think there's often a case to be made as to why their interest actually aligned with your interest as an impact investor. But too often we end up talking to ourselves and not enough time talking and thinking about people who often get groups that get characterized as kind of always being on the other side. And I think it will pay dividends, pun intended, I guess, to think about building those bridges and at least building lines of communication so that maybe then bridges can be built and then partnerships can be built.
That's a super important point, Dennis. I always reminded that there are plenty of cases where regulation lets companies do what they need to do anyway to meet customer and client demand, and do it in a way that doesn't disadvantage them against their competitors. And so they actually, over time, once they've absorbed the initial hit, they actually come to appreciate that regulation pushed them in the right direction. Fran, and then Rick, and then we'll try to get to some of these questions as well in the chat. And if you guys are watching the chat, you can also try to address some of those.
Thanks, David. I think one thing that I want to get across to the group is that we need to redouble our efforts at this time. We think that our response in the months and years ahead will set the stage for a long time. We've heard from Rachel and Rick about the importance of private sector action, and Jorge, private capital allocations, working freely in investor coalition to hold corporations accountable, the system framing that Rick mentioned, and using the private sector to hold both corporations and government accountable. But I just wanted to say a word around public policy and the importance of public policy, which has been a woefully underutilized tool among impact investors. And I hope for folks that don't live and breathe this every day, like the speakers and I do, that you don't hear what we're sharing and pull away and stay out of the fray.
Right.
So the goal is really to kind of rise to the occasion. We've heard a couple of the techniques. I'm happy to itemize them at the end. David, if you prefer, I do so now. I certainly can. But there are ways that you can get involved that are, perhaps lower lift than some of the stuff that we do on a day in, day out basis. Leveraging your voice as private sector leaders, calling on businesses, financial institutions, policymakers alike, working in coalition, whether it's the freedom economy, whether it's freedom to invest, and the Alliance and B-Lab co-lead this coalition on inclusive economic growth, where we welcome your interest in if you're public policy curious and you want an on-ramp, this is a great way to do it. We bring in key leaders from the administration, from Congress to meet with coalition members. We craft sign-on letters, public comment letters, which are so important. Public comment letters will be even more important in a post-Chevron world to show what it is that we as citizens and investors want to see in regulation. So just to say there are on-ramps and to encourage folks to be bold in this moment and not to shrink. And it would be very easy to do so. We're here to make sure that you don't, and I hope you join us.
Great. And Rick, maybe this is thank you, Fran, a way to get into your comment. There was a question about where are the opportunities to go on the offense and to not just be defending, but to be pressing forward.
So look, I think I can combine that a little bit with Fran's point, which is to say, one place to go on the offense as a shareholder who wants to have an impact and who wants to address where we are is to be active at companies on political and public influence. So one of the most important things shareholders can do is push companies to stop using their power to stop the government from doing its job. We all know that we were on the right path. The government was on the right path to climate change, addressing climate change in the 90s, and the oil industry has spent billions of dollars and decades stopping that from happening. And there's almost no single thing you can do as an active shareholder that would have more leverage than stopping companies from participating themselves or through trade associations in this kind of race to the bottom. The other point I just wanted to say, in response to something Dennis said, is like one thing to really, and it's a little meta and not like practical, but we just have to stop thinking that the only measure of success in business is profits. Like, we have somehow converted ourselves to a society where if you're a startup company, what's great if you become a unicorn, which is measured by how much money you make. If you're, in business, what are all the CEOs competing for? They're looking at how much one another makes. And we just live in this world, and that's not how capitalist society has to be. You can look at proxy statements from the 50s and 60s, and companies, I'm not kidding, bragged about how much taxes they paid. They bragged about how much they paid their employees. And so one of the things we have to do at another level is just sort of try to change the water we swim in and get out of this very poisonous water of the only way you measure success in business is by the bottom line.
That's well taken, although I was actually going to go in a different direction, which was I'm taken by the framing that both the Rachel has used and others around freedom, and it's getting some resonance, I think, at the, as they say, top of the ticket as well, and it is kind of does have a resonance. So maybe as we think about closing statements here, talk a little bit maybe about the freedom framing. I think there was a person in the audience, Kim Gadsden Knowles, had a hand raised. Oh, there you are. I don't know if you have video, Kim, but toss your question into the mix here. I think you may be muted. I can't really see. Yeah, you are muted. Isaac, can you unmute Kim? There we go.
I am so sorry. That was a mistake. I didn't mean to raise my hand.
No, you didn't mean to raise your hand. Okay.
No, I'm sorry. Sorry about
That's
that.
fine. That's
But
fine.
it's lovely hearing your voice. And there was another question that was raised about where we can go on offense. And I just want to say there's two ways. And one of those is everyone seems to be aware of, there's some consensus building around the understanding that it's the investors, as the owner of business, it's our fiduciary obligation, right, to ensure that what our businesses are doing are not only good for their own interests, but good for the society at large that allows them to exist. So that's one piece, is like lean in on fiduciary duty. The other is that many companies, in order to appeal to workers and to consumers, have made very public commitments to sustainability and diversity, equity, and inclusion. Why doesn't their political spending align? Proxy filing season is here. I know many will be filing in October. It's a really interesting thing to ask publicly traded companies to align those commitments with their political spending, because it's their political spending that's having an inordinate impact on what laws get passed.
Dennis, we chatted a little bit this yesterday that there might be opportunities. I don't know how you see this to use Loper Bright in the other direction.
Yeah, well, one of the things we're doing is we're looking at some of the rules in the past that have been deregulatory and baseless and wouldn't pass the test under Loper Bright or a whole bunch of other things. So they've been limited to a 6-year look back. Now that you can go back as far as you want. I won't, given the consideration that's happening among some of the groups, I won't identify any of the key ones, but there's a number of organizations looking at seminal rulemakings that lack the valid basis. Now, of course, one of the problems we have in the nonprofit and public sector is getting standing. So there's always a standing challenge, but there are opportunities for offense here in a number of ways that a variety of people are looking at pretty closely.
Okay, let's just have a quick round of closing thoughts, and we often leave the room open. It's a little different than our usual calls where everybody's in the same room. So let's just we'll go a couple of minutes past the hour, but if you each would like to just sum up a little bit, and again, point forward. We've covered a lot of that, I know, but and maybe let's go in sort of the reverse direction. So Rick, you can go first, and then Fran, you'll get the last word.
Well, I think I might have given my closing statement, and
That's fine. You concede your time.
Change the water. So I think I will cede my time.
Going backwards. Oh, well, actually, Jorge, I should have had you. So I'm sorry for I messed up the order here.
No, it's okay. I'm happy to go next. Yeah, I think this point that Fran raised about staying the course is important. And so the question of like, how do we stay the course, and connecting into the last segment around the financial case for responsible business, we are drawing more attention to the fact that customers still want companies to be speaking very specifically to the environmental and social governance issues. And also CEOs are being still held accountable for their public stance on issues. And so I think while we know that there's a lot of anti-rhetoric, we are building and seeing policy initiatives. Just in 2022, there were 22 separate policy initiatives that would advocate for mandatory and voluntary transitions to stakeholder governance. And so those are signals that more is possible. And again, I know we talked a little bit about shifting from federal to state, but that's where the action is right now, and we can be very proactive at the state level.
Great. Rachel, I don't know if you want to touch on the freedom point, but I think that's important framing.
Absolutely. In the end, these attacks are reducing your freedom as an investor, as an owner of these businesses, right, to exercise your full oversight. And it's reducing your ability to outsource any of that to the government. So they're leaving that responsibility squarely in our laps. It's more important now than ever before that you continue doing what you've been doing. You've been seeking out asset managers who understand this critical role of investors and push companies to maintain transparency, accountability, to rein in corporate excesses. Keep doing that. You've been public and you've been collective about making demands on power that protect both people in our communities that are most impacted and also the planet. Keep doing it and know that there's now a legal resource that has your back. Keep doing what you've been doing and join the freedom economy.
Nice. Dennis?
I guess I'd say just two quick things. As Rachel said, and I pointed out earlier, these cases are, and maybe Fran too, I don't remember now, but these cases really are a power grab by the Supreme Court. But I think everybody needs to remind themselves, and I think Rick was talking about this, it's a capitalist society, and the capitalist society, capital is power. You have an enormous amount of power. The question is, how do you leverage it? Where do you use it? What's the strategy behind it? But when you're thinking about capital and you're investing, whether it's for impact or not, you're investing capital. Capital is power. You have a lot of power. The question, you have a lot of power individually, and you have even more power collectively. And leveraging that power and strategically deploying that power can counterbalance the power that's being exerted against you in other places. So that's really important, I think, to remember and remind yourself that, yes, these are bad cases. Yes, things are going in the wrong direction in a number of places. But at the end of the day, capital is power. And that power needs to be used in the right way strategically. And the other thing I just wanted to say quickly is, Justice Brandeis once said, transparency is the best disinfectant. And yes, there's a lot of different things you can do on voting for your proxy and, engaging with congressmen and senators. But at the end of the day, the disinfectant of transparency stings corporations. And even though they're no longer bragging in their proxy statements about being good corporate citizens necessarily, they do like to think of themselves that way. And anything that dings the facade of the good corporate citizen gets a lot of attention all the way to the top of these companies. So you can exercise power as a capital allocator in a lot of different ways, including in the court of public opinion. And you should never forget that the court of law, the court of public opinion, as well as the legislative and executive arenas are all in play and available to you at all times.
Terrific. And Fran, just send us home.
Well, thank you so much for the opportunity to be in dialogue with you all. I'm just inspired by the work of our speakers and the chat going on. I think I said it earlier, I think our field is at a crossroads and in the crosshairs. There's no way we would be in the crosshairs if we weren't making real progress. You know, Rachel talked about it, social, economic, gender progress. We are lagging the world in practicing this sort of investing. We are lagging the world in terms of regulatory, the agenda around corporate and asset manager transparency on impact factors. Dennis said it well, that transparency, free, fair markets, that's something that everyone, I hope, should agree on. We believe that impact transparency will lead to an era of impact accountability, and impact accountability, we hope, leads to more equitable economic, racial, gender outcomes. So I think, just to double down on what Rachel and others have said, continue to do your work, know that you are able to do your work. And for those of you that have the interest and the predilection to get more involved with public policy, it couldn't be a better time, because we need to work together, and we have a lot of opportunities. So I hope you join us all.
Terrific. Well, and I just say ImpactAlpha strives to be a sort of resource in this regard as well, and to keep everybody informed of what all of you and others are doing. There's plenty of good suggestions and good links in the chat. We will round all of that up, as well as the comments on the call itself, and I think have a video replay of the call in the brief on Friday. And if folks who are listening and have more to say should reach out. Editor@impactalpha.com will get to me and the team, and we welcome op-eds and guest posts and certainly news and tips about the developments in all of this. So we will be on the case. I know all of you will be on the case, and thank you very much for joining us.
Thank you, David.
Thank you.
Everybody.
Thanks so
Thanks,
much.
Bye.
Bye-bye.